Hello YouTubers, this is the fifth in my series of videos on the American criminal justice system. In this case, I want to talk about plea bargaining. Plea bargaining is the reality of our criminal justice system. While all the really good drama comes from trial, well over 95% of criminal cases in America, both on the state and federal level, are resolved by plea bargaining. Interestingly, plea bargaining, the constitutionality of it was only ruled on in 1970. And in that case that ruled on the constitutionality of plea bargaining, it was held that where evidence of guilt is overwhelming, then it is not a violation of the Constitution for the prosecution to offer sentence concessions to induce the defendant to plead guilty rather than waste everybody's time at trial to get the result that everybody knows is going to happen, right? So that is actually the basis of plea bargaining. The guy is guilty of sin, everybody knows it, and we are trying to not waste everybody's time. The reality is that sometimes happens, but also there's docket congestion. Especially in the 20th century, more and more stuff have been criminalized, and we just don't have the resources to try every case, especially misdemeanors, right? I mean, we could never try a murder case if every DUI case had to go to district court trial. There are other reasons as well. The way our laws are written, a lot of stuff is criminal, and we rely on prosecutorial discretion to tweak the broadly written laws to ensure fairness on an individual level. I'll give you an example. In Colorado, we have a misdemeanor. It's a class 1 misdemeanor called third-degree assault. Class 1 misdemeanor is the most serious type of misdemeanor before you get to a felony, and third-degree assault carries a penalty of between 6 and 24 months in county jail and a fine of up to $5,000. Probation is also a possibility. Now, third-degree assault is defined as somebody knowingly or recklessly causing bodily injury to another. Bodily injury is defined statutorily as low as pain. So what that means is recklessly is you consciously disregard a substantial risk that something could happen. So if you are in a crowded park where people are running around, walking their dogs, doing whatever, and you decide, you know what, my frisbee throw might not be on target, and maybe I might hit somebody in the head and they might say, ow, but I'm going to risk it anyway. And that's what happens. Your throw is off and you hit somebody in the head and they're like, ow, that hurt. You have just committed third-degree assault, right? And in theory, you could go to jail for 2 years for that. Now, this is where prosecutorial discretion acts to mitigate the broadly written statute. And hopefully, there is no prosecutor who's going to be, you need to go to jail for 2 years or something like that, right? Maybe the DA will drop the case, or other things can work out a plea bargain to mitigate that, to look at the circumstance of your case and give you a plea bargain so that you are not in the same place as the guy who beat the heck out of his wife in some sort of DV situation. So we use plea bargaining as an act of mercy and also to tailor the broadly written laws to individual circumstances. Because if the laws are too individualized, you can't cover every situation, and you're going to write another law, and then it's going to just get unwieldy. You could also use the plea bargaining as a way to respect a victim's wishes. For example, you might have a serious sex assault on child case, and there's like a 5-year-old that you're going to want to put on the stand, or you're going to have to put on the stand for trial, and understandably, the mother does not want that kid re-traumatized by having to testify on this serious sex assault on child, and maybe the prosecution and defense can work out something where they are both satisfied with the result. Well, the DA is satisfied with the result. The defendant can live with the result and would rather not risk trial, right, to work out the case before without trial. Related to that is often a case gets plea bargained because of problems with the case. I think that there's a real question whether or not this is even constitutional, right? The reality is everybody does this, but remember the case in the 70s said when there's overwhelming evidence of guilt, you can plea bargain, right? So how does that work if you've got case problems? Let's assume that the police did a okay investigation, right? Like they actually collected what they were supposed to collect, but they messed up. They went in without the warrant, and they got that got suppressed, right? So you are now missing evidence because evidence that was obtained unconstitutionally, and now you're not going to have that evidence at trial. The DA is not going to have that evidence at trial, and so the district attorney, if the district attorney thinks that he can still go forward with the case without that evidence, it's just going to make it much harder to try. The DA might offer a plea bargain to see if we can get the case resolved without having to go to trial, right? And on the defense side, they might do it to mitigate risk. You know, I mean, it's possible that this guy has some serious mandatory penalties prescribed in law, right? Maybe he's a 3-time felon and this is number 4, and now he's looking at going away for 60-something years, and the DA offers 16 or something. And so from the defense side, they might want to mitigate the risk of trial, and the DA might want to mitigate the risk of trial, and so they plea bargain it. Again, I'm not sure this is actually constitutional, but it is the reality of how the criminal justice system works. In fact, it's the reality in a really weird way now. In I think 2012, maybe 2013, the U.S. Supreme Court came down with two opinions. One was Missouri versus Fry, and the other one was, I can't remember the Attorney General's name, versus Lafler, Lafler. And in those cases, the Supreme Court essentially made the performance of the defense attorney a matter of constitutional Sixth Amendment import. Right? Heretofore, the Sixth Amendment meant effective assistance of counsel, meaning in Gideon v. Wainwright, the state has to appoint a public defender if the person's indigent. And then if the public defender or the private attorney who's hired is so incompetent, right, that the defendant didn't get a fair trial, that might be a due process violation, and that individual gets a new trial because he was denied the due process of law. But that involved trial, because nobody has a constitutional right to any plea bargain. You have a constitutional right to trial, but you have no constitutional right to force the DA to offer you anything. So before these two cases, going to trial, you got your rights, right? You didn't have to take the plea bargain. So what happened in Fry was this guy was offered a plea bargain. He was out on bond. He was offered a plea bargain. His attorney, private attorney, never talked to him about the plea bargain. So he thought he was going to trial, and then he committed another crime. So now the DA makes a much harsher plea bargain, and he ends up taking that. Later, he found out that there was an earlier plea bargain that he could have benefited from, but he didn't because his attorney screwed up and never talked to him. The U.S. Supreme Court said that that was a denial of his Sixth Amendment right to counsel and reversed the conviction based upon plea. In Lafler, what happened was this guy tried to shoot at somebody and only wounded him. Right? The DA made an offer of significant prison, but it was less than what the guy would have gotten at trial on attempted murder. His idiot attorney tells him there's no way the DA is going to be able to prove attempted murder because you didn't manage to hit your victim above the waist. Right? And so he relies on this advice from his attorney, goes to trial, gets convicted of attempted murder, and and gets sentenced for that. And then he appeals, saying that he was denied his Sixth Amendment right to counsel because his attorney was so bad that he gave him this bad advice. Interestingly, his attorney did the trial fine, right? His attorney was not incompetent at trial. His attorney just was, I guess, incompetent in advising him to not take the plea offer that he actually had no right to. He has no constitutional right to this, but he has a constitutional right for good advice from his attorney to take the plea offer. What this means, as far as plea bargaining goes, is plea bargaining is now the criminal justice system. Most cases will resolve by plea bargain, and the U.S. Supreme Court has now made the quality of plea bargain negotiations a matter of constitutional import. So that's what I want to say about plea bargaining today. If you have any questions or comments, please leave them in the section below. Thank you for watching, and I'll see you all next time. Bye.